Hello and welcome to the Regulatory 1515 podcast. My name is Patrick Head. I'm a partner in the Regulatory Services team here at the Maples Group. Joining me today is fellow partner Tim Dawson and team member Jen Parsons. In this video edition, we will cover the latest developments in regulatory laws that have taken place in the Cayman Islands since our last December 1515 podcast. Please note that the contents of the podcast do not constitute legal advice and should be taken as a general update only. In this edition, Tim, we were going to mention some of the beneficial ownership updates. Are you able to kick us off with those?
Yeah, thanks, Pat. So we've had a couple of sets of regulations, one dealing with legitimate interest access and the other one dealing with access restrictions. So linked in a way. I'm going to talk a little bit more about the legitimate interest access than I will the access restrictions regulations. So the background to this is that back in the day, in October 2019, the Cayman Islands committed to introducing publicly accessible registers. And a bit later, there was a court case in Europe in which the ECJ issued a judgment where they declared that public access to beneficial ownership information in Luxembourg and other member states was a disproportionate interference with the rights guaranteed by the Charter of Fundamental Rights. So what you have there is a bit of a kind of conflicting forces, because on the one hand Cayman said, okay, we're going to have public registers. On the other hand, the ECJ said, well, actually, there's an extent to which this is infringing your human rights. So where Cayman's landed is it's going to give access to those who have legitimate interests. So in other words, there's the ability for certain people to go and make searches of the beneficial ownership information, which is uploaded by corporate services providers to the central registry. Beneficial ownership transparency, legitimate interest access regulations have been approved by Cabinet. They set out how these searches can be made. They're not enforced until 28th of February 2025. Now, who can make a search? There's a few kind of limited categories of person. One is journalists. Then there are so-called civil society organizations, which is basically things like NGOs or trade unions. And then there's also the possibility for those who are actually in a business relationship with a legal person to make a search. In all cases, you make a search on the basis of suspected money laundering or terrorist financing or proliferation financing kind of activity. You're going to have to prove both your credentials as a journalist or a civil society organization or having a kind of a business relationship in order to make a search. There's a very small search fee of 30 Cayman dollars, and you can kind of compile related searches for which there's a fee of $100. But you make searches in respect of entities, not individuals. So you can't turn up and just make a search for Pat Head. That's not allowed. If there's a known PGH Limited, then that might be something you can make a search in respect of, provided that you demonstrate, again, your credentials and the fact that you have a sort of suspicion of some sort of money laundering offence. So that's coming into force on 28th of February. I suspect that one of the reasons for the delay is that the access restrictions regulations are already in force. And this basically allows for people who have a kind of legitimate fear that kind of dissemination of their beneficial ownership information could lead them to being at serious risk of kidnapping, extortion, violence, intimidation, or other similar danger or serious harm. Now, if you make such an application, it doesn't stop you being it doesn't stop your information being uploaded onto the kind of registers which are searchable by the public authorities, but it would mean that if someone made a legitimate interest access search in respect of a particular entity and you were associated with that entity and the government had accepted or the registrar had accepted your application to be removed from the kind of search function, then you wouldn't be your information wouldn't be produced as a result of that search. So those are the kind of, I guess, the major changes which have arisen. I mean, a couple of other things to mention. The Cayman Islands economic substance regime, where in certain instances you have to report beneficial ownership information, and until very recently, the definition of beneficial ownership information was still that belonging to the previous beneficial ownership registry regime. So there's now been an update by regulations to make sure that when you're defining beneficial owner for purposes of economic substance returns, you're applying the new Beneficial Ownership Transparency Act regulation. And just a final point, there's an amendment bill with respect to the kind of primary legislation to make some tidy ups. I'm not quite sure when that's going to come into force, but that's looking at amending the definition of beneficial owner when you've got a trust and a structure, and there'll be circumstances in which the trustee of a trust will be identified as a contact person in respect of a legal person, and failing there being a trustee or a registered beneficial owner where there is a trust, it'll be senior managing officials who are nominated. Law now will provide that non-profit organizations are out of scope.
That's great. Thanks very much for that, Tim. I was just going to chip in here with a very quick update on the VASP amendments as well. And I know that I spoke about the changes to the main act in December, and I also made the comment, I think, in our last podcast that industry was a little bit disappointed there hadn't been anything with respect, particularly to the tokenization of interest. And then, as a sort of belated Christmas present, that came through at the very end of December of last year. There was a bill passed, which thankfully talks about allowing for the tokenization of equity interests in regulated investment funds. Now, that's welcome news, I think, to the industry at large. And again, that is only a bill at this stage; it's not yet passed into law. But once that does come through, that actually, I think, will be very, very helpful in this jurisdiction, particularly, and pave the way for the tokenization of regulated investment funds in Cayman, which I think is an exciting news and a good development on the sort of the crypto side of the fence and space for Cayman. So I'm looking forward to a little bit of work in that regard for 2025. So obviously we'll keep listeners aware and updated as and when that bill is actually passed. And I think also there were a couple of updates towards the end of last year issued by CIMA. So Jen, if you're able to run us through those, that would be great.
Yeah, thanks, Pat. So, I mean, the main thing I think we want to highlight here is that CIMA published a new FAQ, frequently asked question, and within that FAQ, in effect, it provides an extension of up to 6 months for the holding of an annual operator meeting for a registered investment fund. So, in effect, what you have is the new FAQ contemplates that the number of operator meetings that are going to be reflected in the fund's fund annual return that's filed each year. It's not necessarily restricted to meetings held within the relevant financial reporting period, as I said. So if you're filing your fund annual return, which gets filed 6 months after the year end, so coming up to June 30th, that would be, you're filing for the prior year end. And let's say that's for 2024, given that that's going to be the next one that is going to be filed. You're not necessarily just having to record within that FAR form the meetings that happened through calendar year 2024. It's possible you could have a meeting in 2025 if that meeting pertains to matters, to do with activity in 2024. Now, the key would be to make sure you're not double counting any meetings in terms of, if you've had a meeting in 2025 that pertains to 2024 matters, make sure it just ends up in that 2024 FAR form. Don't then again, when it comes time to file the 2025 one, count the meeting that actually, you'd already counted in the prior filing. So just be aware of that. It's a modification that extends and recognizes really the way that investment funds operate, and the fact that there can sometimes be a lag or delay in when certain information is available and when it is considered, despite it actually pertaining to an earlier time period.
Yeah, thanks, Jen. That makes a lot of sense, and I agree that that's a good practical solution there, and sort of recognition of the way the funds do operate and access information and the timing. All right, I think that they're moving on to FRA updates, and I know that everybody's been sort of in the local industry focused on this implementation of changes around the filing of suspicious activity reports, and in practice, what the practical changes are going to be here. So Tim, I know you've been reading up on this over the holiday period with a cold beer in hand, so please do educate us all.
Yeah, thanks, Pat. So some background on this is that historically in Cayman, if you filed a suspicious activity return, that was pretty much all you needed to do to have a defense against a charge under the Proceeds of Crime Act with respect to non-reporting. That regime has now changed towards the beginning of last year. A Proceeds of Crime Amendment Act was published, which introduced a consent regime. So pursuant to the wording in that Amendment Act, if you're filing a SAR and explaining that, for instance, you want to make a transaction, make a payment to someone, you now would have to get the consent of the FRA before proceeding. Now, what the FRA were hoping to have before the end of the year was an extension to the coming into the force of that regime. But I expect because there was so much government business, that didn't get onto the order paper. So technically, from 2nd of January, that amendment has come into force. So what the FRA has done instead is issue an industry notice, basically explaining how they think the regime is going to work and pending further regulations and guidance, which will be subject to consultation. So now what you have to do is you file your SAR, but if you're filing a SAR on a basis that it is a defense against anti-money laundering or DAML, you actually have to make that very clear as part of your filing. You submit it in the ordinary course. You may get authoritative consent, but there's a deemed notice period of 7 working days, commencing on the first working day after the request has been received. And so basically, if you haven't heard anything within those 7 working days, then there is deemed consent and you can continue with the transaction which you are hoping to undertake. If consent is refused, then there's a moratorium period of 30 days. And during that moratorium period, the activity, which is the subject of the request, should not be carried out, or else there is a risk of a money laundering offence. Presumably during that 30 days, if thought necessary, the FRA will go and get a court order or refer the matter to the police for further investigation. But anyway, this is very welcome. It's very sensible. Basically a deemed consent process, which I think very much copies the kind of UK process and hopefully provides clarity and a workable process for industry.
Yeah, thanks for that, Tim. I'm aware that I think the FRA are sort of giving some further talks, a bit of feedback on this sort of, and I'm sure there'll be a few more nuanced questions as we work through it until the actual guidance and regs are in place. But that's a really helpful update and will allow people to continue conducting business as normal in the interim. Otherwise, just like to say that then concludes the episode. I'd like to thank everybody again for taking the time out of busy schedules to listen. And I hope you've enjoyed this episode. Please do rate us on your usual listing app and or subscribe. And hope everybody has a very prosperous 2025. Thanks all.